Reeves Immigration Law Group now brings you Immigration Law on Your Side.
Alright, magandang gabi mga kababayan and welcome to another Immigration Law on Your Side episode dito po sa PHLV Radio. Kuya Yo, galing po sa Las Vegas, Nevada. Siyempre kasama po natin via Zoom from San Francisco, California si Attorney Flomi Javier Diza. Ilang taon na rin natin ginagawa ito. Patuloy po ang ating serbisyo publiko sa ating Immigration Law on Your Side. Hatid po sa atin ang ating mga kaibigan from Reeves Immigration Law Group. Mga kaibigan, ang pag-uusapan po natin ngayong gabi ay ang tungkol sa Prosecutorial Discretion after the U.S. Supreme Court decision on Texas versus U.S. Alamin natin kung ano ito. Mga kababayan, on June 10, 2023, kamakailan lamang the U.S. Supreme Court handed President Biden's administration a victory in a long-running fight about how to enforce the nation's immigration laws. Again, let's have Flomi Javier Diza at Reeves Immigration Law Group to help us understand how the U.S. Supreme Court decision will affect people who are in removal proceedings and those who have violated their status. Magandang gabi sa iyo, Attorney Diza.
Good evening, Kuya Johan, and to all our viewers and listeners. Good evening, good morning, good afternoon sa inyong lahat. At of course, very timely ating pag-uusapan ngayon. I know that we cannot recycle our topics, although, may mga updates. And as you recall, this topic has been discussed here at PHLV Radio nung in-implement ni President Biden, right, ang prosecutorial discretion in 2021. But again, there were lawsuits that came and eventually it reached the U.S. Supreme Court. And as you mentioned, they handed a decision in June 2022, and we're back on prosecutorial discretion. In fact, I still remember, Kuya Johan, our topic on prosecutorial discretion last time was prosecutorial discretion is back, are you eligible? So the same thing ngayon, there were differences, there were updates that we are going to update and inform ang ating mga listeners and viewers.
All right. Bago tayo, Attorney, tumawid doon sa bagong Supreme Court ruling, Attorney, bigyan natin ng konting background ulit ang ating mga listeners and viewers on PHLV Radio. Kung ano po itong prosecutorial discretion, Attorney, at konting background po.
Yes, if you recall, mga kababayan, this is not new, ang prosecutorial discretion. It has started also during President Obama's time in 2014, where he initiated yung DACA. Not only the DACA, yung Deferred Action for Childhood Arrivals, but also yung prosecutorial discretion that has the authority, the government has the authority to, prosecute, right? Or discretion to prosecute yung mga overstay or people who were already in proceedings, right? So if you were in proceedings, either the government would agree into the dismissal or termination of your case, and this became a very helpful tool sa mga practitioners kagaya natin, lalong-lalo ng mga clients natin who were in proceedings na walang strong relief, right? So we were able to dismiss or what we call administratively close the case while waiting for their relief in immigration court. So as we all know, during President Trump's time, right, he stopped the prosecutorial discretion, and iba ang kanilang policy when it comes to overstay. Unang-una, during President Trump's time, ang kanilang priorities were people who, not only people who have overstayed or rather who have criminal conviction or repeat offenders na mga nag-cross the border or people who have prior removal orders or criminal convictions, but basically all people who have violated their status, kagaya ng mga kababayan natin na nag-overstay or nag-violate ng kanilang status. So yun na bago yun, and then when President Biden, one of his promises during campaign was to stop deportation, and in fact nag-issue siya ng mga memorandum. There was this Mayorkas memorandum, there was this Doyle memo where it says that ang mga priorities nila, Kuya Johan, ay tatlong grupo, di ba? Ito yung mga people who are threat to national security, right? Or people who are involved in terrorism, or people who have serious criminal convictions, and people who have repeat offenders, or people crossing the border all the time. So those were his priorities. So people in removal proceedings, pwede silang mag-request ng prosecutorial discretion to either dismiss or terminate their case. Ito yung history ng case. Ang prosecutorial discretion, Kuya Johan, does not only apply sa mga DHS, the Department of Homeland Securities or immigration judges. If we recall or if you try to correlate yung mga may criminal convictions din or may mga criminal cases, yung mga nasa district ano tawag dito, yung prosecutor, whether to prosecute people right in court and have them convicted of their violations, ganito rin sa immigration, right? Civil enforcement, civil violations, pwede silang i-prosecute or dismiss the case like in this prosecutorial discretion.
So ano po, attorney, ang naging latest decision ng Supreme Court hinggil dito?
Yes, the Supreme Court held a vote of 8-1, no, that the state has no legal standing. Ibig sabihin, wala silang right to bring the lawsuit against the US. So basically, it's more of procedural, hindi yung tipong valid ba yung ginawang policy ng Biden administration. Ang sinasabi lang ng court, wala kayong standing. Yung Texas and other courts held na walang standing, which is a good way kasi na-reinforce o na-reinstitute na yung policy ng Biden administration when it comes to prosecutorial discretion.
Sa ating mga kababayan attorney who has current case with the USCIS, ilan sa mga kliyente natin, ilan sa mga kakilala natin, what's the effect sa kanila, direct effect sa kanila nitong decision na ito, attorney?
So yung mga since this decision has been reinstituted, yung policy of the Biden administration when it comes to the removal proceedings, right? Marami na silang mga rights, right? So number one, mga kababayan natin, discuss muna natin, Kuya, yung people in proceedings. So anong pwede nilang gawin? Right? Unang-una, you have to talk to your attorney, or kung wala kayong abogado, of course, to talk to an attorney and discuss kung ano yung options po ninyo, right? So alimbawa, yung kliyente na natin were nag-consult sa atin where they have serious criminal records in the past, right? At sila nag-travel sa Pilipinas and then pagbalik, they were held and they were detained by the CBP and they were referred to immigration judge. In that situation, lalong-lalo na yung mga mahina ang kaso or wala silang relief just because of the nature of their conviction, right? We can try to apply for a prosecutorial discretion, meaning requesting the government to either terminate or dismiss the case. So yun yung posibleng scenario. Or yung mga client naman na nag-file ng halimbawa adjustment of status where it was denied because of either my fraud, my criminal records, my prior removal order, or simply because may marriage fraud or stuff like that. So they were referred to immigration court, no? Itong prosecutorial discretion, Kuya Johan, as we speak, the government has the authority to stop or to even refrain from filing a notice to appear, right? So instead of you referring to immigration judge, pwede rin ang DHS would say, hindi na natin i-refer to because they are not one of the listed priority. Yung nabanggit natin kanina na terrorists, national security, and repeat offenders. So instead of doing those, nandun ka lang. Kaya lang, again, even if you have a denied application at hindi ka i-refer sa immigration judge, it doesn't mean na you have the status already. So babalik ka sa status quo where, before you file your application, kung wala kang status, overstay ka pa rin, di ba? Wala ka pa rin work permit, wala ka pa rin legal status. So really important, again, circle back natin doon sa, consulting a lawyer and discuss what are your possible options. So yung scenario na yun, Kuya Yon, or a scenario where a client was referred to immigration judge and then yung anak niya, may anak siyang US citizen na 18 years old or 19 years old, for example, na hindi pa siya pwedeng petisyonin dahil kailangan maging 21 ang bata bago ma-petition ang family, pwede ring i-request ang government lawyer, or yung ICE lawyer, and then file a motion with the judge to either admin close the case or even dismiss the case, right? Para lang, hintayin na yung anak na mag-21, right? Para doon na nila i-file yung petition once the child turns 21. And why are we doing this? Why are we pushing for prosecutorial discretion to dismiss and terminate the case. Again, gagawin natin yon if you have a very weak case. And pangalawa, kung meron kayong hinihintay, di ba, na relief, yung sinabi natin kanina na magto-21 na yung anak nyo US citizen, or for example, yung priority date nyo from your mom, or your parents, where they filed a petition for you as a married person at naghintay ko yun, 20 years to become available, malapit na. So, you can always request the judge. Instead of the judge proceeding with the what do you call this, the case, either as a very weak, asylum claim or a very weak cancellation of removal, or even yung napag-usapan natin last time, kuya, yung mag-request ka ng voluntary departure, right? It's better for you to file a request for prosecutorial discretion na pwede bang i-dismiss na tong kaso or stop natin yung kaso, i-close muna natin habang hinihintay natin yung administrative relief. So yung mga possible scenario, Kuya Johan, yung options po ng mga kababayan natin, right, pag nasa immigration judge sila. So either, request for dismissal or also request for termination, right? Or, pwede rin pag-usapan yung gobyerno na, hey, nanalo na ako sa case na to, can you just stop or, refrain from appealing the case, right? So may mga cases na ganyan, Kuya Johan, at whether at the stages of proceedings, whether nasa immigration judge kayo, pending yung case nyo before the judge, naka-appeal na kayo sa Board of Immigration Appeals or yung next level of appeal to the Ninth Circuit Court, you can always request this prosecutorial discretion by, contacting your lawyer and, of course, contacting the government lawyer.
Attorney, when if you so decide that this is the route that you are going to take, will there be additional supporting documents na baka hingiin sa ating mga kababayan?
It's really important that when you file anything with the government lawyer or immigration judge, this should be supported by strong evidence and supporting documentation, right? So it's not enough na, hey, I want to get out from the removal proceedings, can you just terminate the case? No, it's not as simple as that. So you have to have this, to discuss with your lawyer and evaluate the case, and you need to prepare a very good reason why the case should be dismissed or terminated, no? So ano yung mga equities ninyo para i-dismiss ang kaso, di ba? You can say that, I've been a resident of the US for over 10 years, 20 years, 30 years, right? I'm paying for my taxes. I have a spouse or children or US citizen parent, or lawful permanent resident parent whom I am taking care of. Right? I have committed a mistake in the past. I committed fraud, but that was 20 years ago. But now I come in clean and, corrected my mistake. And of course, your criminal records, for example, if you have a very serious criminal records like drug use or drug abuse or even domestic violence, for those we term as aggravated felony, right? If those happen years ago, right, and then you have to show rehabilitation. So, for example, if you were convicted of drug use, right, you were a drug user in the past, you should show that you were rehabilitated. Nagbago na kayo at, you attended those seminars or schools or classes para lang maging clean ang inyong records. So, and of course, a letter from your friends and your family attesting to your good moral character, right? Mga employers po ninyo and co-employees, co-workers, those are very helpful supporting documents when you request for a prosecutorial discretion.
Will a fingerprint-based FBI background check be required, attorney, to support yung pagbabago niya?
Yes, once you file an application with USCIS, whether adjustment of status, asylum, or cancellation of removal, or even voluntary departure, right? The government requires you to do a biometrics or fingerprints. So once you have that record already on file, what the government does is, aside from your supporting documents saying I don't have criminal records, the government can run, their system and see if you have a hit, what we call hit, or it's showing that you have criminal records. By that alone, the government can confirm, right, that you don't have a criminal record. So if it's not clear for them, right, then you should undergo a criminal request for a fingerprints through the FBI or through the Department of Justice, right? California Department of Justice or Nevada or wherever state you are located to request for a FBI prints.
That's right. Okay. Attorney, when someone has a hearing date already, how far ahead of that can they request or file for the prosecutorial discretion?
It's really a great question, Kuya Johan, because what I do personally, even if they're FAQs, no, and practice advisories, they would always say that 30 days, before the hearing, at least, 15 to 30 days, to give them time. Ako, as far as, yung mga hearings ko in 2025 to 2027, right, if I think I have a good relief, I usually request already and bag them, and it works, kapag mabilis ka. And the reason being that, Kuya Johan, for example, I have a client that was scheduled in 2025, for example, and part of the prosecutorial discretion is not just to dismiss the case or terminate the case. We can also request them, right, to decide the case based on what you submitted. So what I do is when my client is placed in removal proceedings, and I know that they have a very good relief, I file the application right away, right? The problem here is, you still have to update pag parating na yung hearing mo. But for me, strategy-wise, for our firm is to file already our documentation, even if the hearing will be far away, right? And the reason being that is once you have filed your supporting documents and your applications, we can request already, right? If you think you have a very, very strong case, that you can request what we call a motion to decide the case based on records. So, ibig sabihin, nire-request mo yung judge, pwede ba na wag na natin i-hear yung kaso, desisyonan mo na lang yung aking case based on what we submitted. Kasi ang ite-testify naman ng client, Kuya Johan, is yung kanyang testimony, yung kanilang statement na provide, right? At saka yung mga supporting documents, how sorry he was or how he committed fraud, how he committed the crime, and what are the rehabilitation and good moral characters. Because basically when you go to immigration court, it's a balancing of equities, di ba? Yung hardship mo ba, yung ginawa mong kasalanan versus yung ginawa mong kabutihan. So, i-weigh in nila yan. So, kung mas matimbang yung marami kang kabutihan ginawa, siyempre ibibigay sa iyo ang relief. So, one of the strategies that we do, as we mentioned, is, coordinate with the government attorney as their position, like counsel. I already submitted, supporting documents when it comes to this relief. Would you be willing to join us in filing a motion saying that that my client will no longer need to testify? So instead of waiting the 2025 hearing, which is about 2 years, 3 years pa, why can we just ask the judge to grant the relief based on the records? And it worked. I mean, many situations, Kuya Johan, as you mentioned, pumapayag sila, and it really saved a lot of time. Not only sa aming abogado, sa kliyente, but also ang immigration judges and trial attorneys, right? So, plus, we are helping them to ease their backlog. Kasi as we mentioned in the past, and it's still applicable now, there are millions and millions of respondents na naghihintay ng kanilang individual hearing para lang papakinggan sila at either bigay sa kanila ang relief or i-deny ang relief nila. And as we mentioned then in the past, statistically wise, ilan lang immigration judges natin, right? May 500 ba? It's probably less than 1,000, and it's going to be the nationwide, right? And there are millions of people who were referred to immigration court. Hindi lang naman yung mga nag-a-apply dito na-deny ang kanilang relief or may mga criminal records, kundi yung mga millions of people also crossing the border requesting for relief, right, asylum, and if they get denied, they are referred to immigration judge. So this prosecutorial discretion is really a great tool for practitioners, for the respondent, if they have a very good case, to help the government to ease their backlog and overburdened immigration court.
That's right. Kaya mga kababayan, alam niyo po itong episode na ito, if you're just joining us today, hindi lamang ito yung regular FAQ or regular informational episode. Ito ay strategy. Importante ito. Kaya that's why if you're in a bind, kailangan kumontak sa ating mga kaibigan sa Reeves Immigration Law Group. Attorney, at this point, we're gonna head over to a break. I know meron kang magandang update para sa ating mga kababayan, but paano po nila makokontak ang Reeves Immigration Law Group if they have something to consult, especially regarding prosecutorial discretion?
Ang aming opisina ay nandito sa San Francisco where I'm based. We are located in the financial district. It's very accessible sa mga public transportation, BART, Muni, tren, yung cable car, nandyan yung ano pa ba, pwede rin mag-bike kung gusto niyo. It's very accessible actually. And then we also have an office in in Walnut Creek. You can also go there. I usually go there twice a month, or we can do Zoom consultation if you don't want to see me in person, right? We have office also in Los Angeles. That's where our main office is, where the most of the partners, work. We also have a staff and office in Makati, Philippines, and one in China. So you will see our contact information and our website www.reevesimmigration.com. You can look at our case team, mga partners and lawyers, and what we do as immigration lawyers. Remember, mga kababayan, Reeves Immigration Law Group have been here for almost 40 years na yata, Kuya Johan, and combined experience among lawyers is hundreds of years, right? And also, we do immigration only, like 99%. Lahat ng klase ng immigration, mapa-deportation yan, family-based consular processing worldwide. We do employment-based. We have EB-5, E2s, H-1Bs. Lahat po ng immigration, J-1 waivers. So, name it, we do have expertise in all aspect of immigration. You can see our phone number there, 415-568-3777. We have a consultation fee of $100, but if you mention PHLV Radio, we can waive your consultation fee and we can even lower, give you a discount, if you decide to hire our services.
Wow. Okay. So tawagan mga kaibigan natin from Reeves Immigration Law Group. Phone number nandiyan po sa screen, 415-568-3777. Attorney, we're gonna head over to a break, but before we do that, baka meron pa po kayong ibang takeaways para sa ating mga listeners and viewers regarding prosecutorial discretion.
Yes, yung mga clients na wala sa immigration judge, and naghihintay ng immigration reform, it's really important for you to consult an attorney and discuss your options. There might be an option there for you, right? Don't wait years and years and years, right, to consult a lawyer only to find out na meron pa kayong posibleng relief. I have a client recently, Kuya Johan, nandito ang parents niya, and it's over been like 15 years. Sabi ko, pinetition ka ng mom mo, right? 15 years ago, is available na ang visa, and what pang hinihintay mo, and di daw niya alam, etc. So it's really important, mga kababayan, to speak to an immigration specialist, immigration lawyer, to discuss your concern, your issues. There might be some other ways to legalize your status. That's number one. Number two, people in removal proceedings. This is a great way, right, to get out of the removal proceedings, lalong-lalong kung medyo mahina ang case ninyo, right, at meron kayong future immigration relief, is to do this prosecutorial discretion, discuss this with your lawyer, right? It's really a very helpful, resources, process for you to get out of the immigration court. You can request for admin closure as well, right, and maintain your work permit until such time na maging available po kung ano yung hinihintay po ninyong relief. Okay. Yon ang advice natin sa mga kababayan natin, of course, to discuss yung if you have a case or if you have a pending case, to talk with us or to any immigration lawyer.
All right. And if you're a listener of PHLV Radio, connect with us. And sigurado pong makakaabot kay Attorney Diza ang inyong mga case na gusto nyong mapatingnan kay Attorney Diza and sa kanyang team sa Reeves Immigration Law Group. Mga kababayan, we'll head over to a break. When we come back, meron pong balita at update si Attorney Diza hinggil po sa employment authorization. Marami sa inyo nagtatanong regarding that. So dyan lamang po kayo. We'll be right back.
Reeves Immigration Law Group has been representing immigrants for nearly 40 years. Reeves Immigration Law Group has been fighting for its clients through experience and expertise. With immigration lawyers you can access at reasonable fees, even on Saturday. Payment plans are also available. Call us for your immigration solutions. We can do worldwide telephone and Skype consultations. Reeves Immigration Law Group, 1-800-795-8009. Reeves Immigration Law Group has offices in Los Angeles, San Francisco, China, and Philippines. See us at www.rreeves.com. Reeves Immigration Law Group, 1-800-795-8009.
All right, welcome back to Immigration Law on Your Side right here at PHLV Radio. We're coming to you live from Las Vegas, Nevada. Si Attorney Diza nasa San Francisco, California. Every Wednesday po kami alas 7 ng gabi dito po sa Las Vegas, sa Pacific Time. And kung nasa ibang lugar naman po kayo, mangyari lamang po, balikan ang ating mga episodes sa iba't ibang mga channels and platforms ng PHLV Radio. Katulad po ng ating podcast episode na nasa Spotify, iHeartRadio, Apple Podcast, and Google Podcast. Attorney, bago tayo nag-break, ay binigyan natin ng teaser ang ating mga kaibigan, mga kababayan, and mga listeners, viewers, na meron po kayong update regarding employment authorization. Attorney, give us the news.
It's really good news for people who have a pending case when they renew their work permit. It used to be, Kuya Johan, 1 year lang yung validity ng work permit, and sometimes it's kind of a pain on their part because, naghihintay sila ng approval, and sometimes mag-isang taon na, nakafile na yung application mo, wala pa yung approval mo. So there are situations where, your employer will terminate you dahil wala kang maipakitang work permit, and in the past, kapag wala kang work permit, at walang approval, that means na, big companies will not acknowledge just the filing of the work authorization. Now, during the Biden administration, ang ginawa niya is, okay, i-file natin yung work permit mo, and then kahit hindi pa na-approve yan, automatic extend natin, di ba? So may mga 180 days, may 500 plus days, in-extend nila, especially during the COVID where ang tagal ng process, di ba? So kawawa naman yung mga tao na nagre-rely doon sa work permit para ma-continue ang kanilang trabaho. And siyempre, if you work in a big companies like mga airports or sa mga Tesla, right, where they do audits on the I-9s, right? So kung wala kang work permit, terminated ka and you lose your seniority, and that's going to be a pain and frustrating for clients, no? And even if we write them a letter, hindi rin na-acknowledge, lalong-lalo na kung wala yung automatic extension, which is good, nagkaroon ng automatic extension. But even with the automatic extensions, there were a lot of issues then, Kuya Johan. So what happened is the Department of Homeland Security, right, extended yung validity ng work permit for 5 years, which is a very good news sa mga kababayan natin dahil number one, right, kapag nag-renew ka kasi ng work permit, magbabayad ka ng filing fee, right? It's I think 425. That's number one. So kung every year yan, malaking bagay din yan. It's not only that, Kuya Johan. We lawyers will also, charge professional fee because, alam mo na, we work on the case, we file the case, right? And we follow up. So malaking bagay din yon. So yung every year ka nagbabayad ng filing fees and or professional fees, malaking tulong sa mga kababayan natin yan. So it's really a good news, and of course also advice sa inyo na pag may pending application kayo at pa-expire yung inyong work permit, don't wait the last minute to file, right? You can file 6 months in advance, right? Wala namang mawawala sa inyo kung 6 months in advance, lalo-lalo na 5 years. Kasi there are situations na, let's say 1 month in advance mo final or 2 weeks before mag-expire, right? There are situations na either tumalbog yung check po ninyo or mali yung address na binigay ninyo, may mali ka sa form, wala kang signature or nakalimutan mo na i-fill out yung form correctly, there's a probability na pag binalik yun sa inyo, right, at nag-expire na yung work permit mo, walang automatic extension yon. The automatic extension only allows you if you file your work permit before it expires. So once it expired, wala nang automatic extension. But at least, kung mabigyan po kayo ngayon, and that's the good news now is, 5 years ang ibibigay sa inyo. Yun yung number one updates natin sa mga kababayan natin, right? Continue renewing your work permit if you are eligible, and of course, pay your contribution to the U.S. government by paying your taxes, because it's going to be, as we mentioned kanina, balancing of equities, right? You're filing your taxes, you're working, you're contributing to the U.S. economy, right? And that's going to be a positive factors in your case.
Attorney, maraming mga tanong papasok para sa ating discussion na ito sa ating mga kababayan. Pero I'll just pick one. One of the things that tinatanong nila regarding itong employment authorization, while they're waiting for their status, meron silang employment authorization, nakakapagtrabaho sila. Ito daw pong employment authorization, can this be used as a travel document para umuwi ng Pilipinas at bumalik, or hindi po ba?
No, it's a separate application, but you are entitled to apply one, right? There are certain pending applications, as we mentioned kanina, na pwede mag-apply. Like, limbawa, nag-file ka ng adjustment of status, right? You can apply for what we call advanced parole. Advanced parole meaning that you can travel, right, upon approval ng inyong application ng advanced parole, right, to outside the U.S. once that's approved. Even if you had overstayed in the past, that's a possible scenario. Just make sure that you have a travel document approved. Now, in the past, Kuya Johan, nung binigyan ng 2 years ang work authorization, 1 year or 2 years, ginagawa nilang combo. It's a combination. All right? It's a one card that says travel authorized, work authorized. So, but it requires a separate application. Mag-file ka ng 765, which is the work permit or work authorization, and then the I-131, which is the travel document known as the advanced parole. Now, once you get approved, in the past, binibigyan ka ng combination. So, you can, to answer your question, yes or no, kasi yes, in a sense na kapag nag-apply ka at na-approve ka at nasa combo card mo yon, then you can use that to travel. Make sure that it says, I-131 approved or travel authorized. Because kung work authorization lang ang in-apply nyo po, hindi automatic na bibigyan kayo ng advanced parole. You need to file that separately. Now, with regard to the 5 years, I'm not sure if they're going to combine 5 years, right? I don't think they would, because there are situations na hindi pwede mag-travel yung mga kababayan natin, di ba? Lalong-lalo na nasa removal proceedings. They cannot just travel while the case is pending before the immigration court, simply because if they do without authorization from the government lawyer, hindi advance parole yan, it's kind of like permission, right? They would then voluntarily depart, nagkaroon sila ng removal proceedings. So we don't advise them to travel, right? Even if, request an authorization from the government lawyer, still, if you are in proceedings, it's strongly advised na huwag sila mag-travel.
All right. I'm sure mga kababayan, marami pa kayong mga gustong itanong kay Attorney Diza. Kaya mangyari lamang pong i-comment sa ating Facebook page, sa YouTube, or i-send sa atin dito sa PHLV Radio info at phlvradio.com, and makakarating po kay Attorney Diza. Now, Attorney, maraming salamat. Maganda po ang ating naging discussion today regarding prosecutorial discretion after po nitong decision ng US Supreme Court nitong June lamang. And also, nabigyan natin ng update ang ating mga kababayan regarding the good news ng employment authorization ay valid na ngayon hanggang 5 years. Attorney, I'll give you this time to address our audience. Baka meron po kayong ibang takeaway para sa kanila.
Yes, there are two things. Another update ko yan very briefly. Ang visa bulletin ngayon, if you look at the October visa bulletin, we're hoping na dadamihan nila ng visa availability, but apparently hindi. So yung mga F2As, as we mentioned in the past, dating current and available yan. If you're petitioning a minor child, you're a green card holder, current and available ang visa, but unfortunately ngayon may retrogression, right? If you are in the Philippines, it's now back to like 4 years, right? Wow. So it's better for you, number one, to file now if you haven't, and number two, file for your naturalization or citizenship, because if you file for your child and then you become a citizen, you can always upgrade, right, to immediate relative. And take note with this, take advantage of this administration. Mabilis ang application for citizenship ngayon, right? Mga 3 to 6 months yan, meron na kayong interview, and once you pass the interview, you would do same day oath. There are offices nationwide that conduct same day oath taking. So take advantage of that. Number two, Kuya Johan, ang Integrated Bar of the Philippines California chapter, we do render free legal consultations at the consulate in San Francisco every first Friday of the month, right? So lahat ng mga issues po ninyo tungkol sa lupa sa Pilipinas, right? Namatayan kayo, probate ng mga cases ninyo, right? All lawyers in California who are licensed in the Philippines, and most of us, there are many of us here also licensed in the United States, would render a free consultation every first Friday of the month from 1 o'clock. I'm sorry, from 10:30 to 12, and from 1 o'clock to 3 o'clock. Now, we are also coordinating with other lawyers, on the other parts of the U.S., like Los Angeles, where yung Las Vegas jurisdiction, to do the same thing, right? And also New York and other parts of the U.S. where the Philippine Embassy has, offices. So, watch out for those. So, hopefully, we can expand our legal service, hindi lang dito sa Northern California, but throughout the United States. Again, with that note, Kuya Johan, thank you very much for always having me here. Reeves Immigration Law Group, we are here to, render public service sa mga kababayan natin. And if you have questions, it's a lot better to consult, through telephone or by Zoom or in person, rather than doing a Google search or just listening to we encourage you to listen, but don't just rely on itong sinabi ni Attorney Diza, because every case is different. No, there are no two cases that are similar. Kahit gaano pa sila ka-similar, there are different, possible different outcomes. With that note, Kuya Johan, again, thank you so much for having me, and mabuhay po tayong lahat.
Maraming salamat, Attorney Diza, for your time and the information that you imparted to our listeners and viewers. So we will have you again next time here at Immigration Law on Your Side. Mga kababayan, tumutok lamang sa PHLV Radio, and congratulations sa IBP sa inyong ginagawang napakagandang serbisyo sa ating mga kababayan. And we look forward, Attorney, for the services in Los Angeles and covering us here also in Las Vegas, Nevada. Again, from Las Vegas, ito po si Kuya Yo, si Attorney Diza, galing po sa San Francisco, California. Ito pong Immigration Law on Your Side right here at PHLV Radio. We will see you next time.
Reeves Immigration Law Group has just brought you Immigration Law on Your Side, Wednesdays, 7 p.m. Pacific on PH